You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diament, founder of Diament Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast, episode 128, the Medical Procedure Exemption. My name is Adam Diament, a registered patent attorney and founder and owner of Diament Patent Law in Los Angeles, California. I can be contacted through my website at diamentpatentlaw.com. That's DIAMENT patentlaw.com, or call me at 424-281-0162. I've talked about lots of kinds of patents and what they do. And if you remember, a patent doesn't actually give you the right to do anything. It gives you the right to stop others from making or using what's in your patent. And there can be lots of kinds of patents. I do a fair number of medical device patent applications, and oftentimes a medical device will have a method of using it, or sometimes there's no device at all, but a doctor has come up with a new treatment method or a new surgical technique. Let's take an example. Let's say a doctor came up with a new way to suture a wound and got a patent on it. I'm going to make up an example of a claim that is really just a fancy way with patent languages on how you would do two stitches. A method of performing surgery comprising the steps of inserting a needle connected to a suture inside a person's body at a first position, pushing the needle through soft tissue of the person's body, pulling the needle out of the person's body, inserting the needle at a second position in the person's body, pushing the needle through the soft tissue of a person's body, and pulling the needle out of the person's body. It's not exactly how you'd write the claims, but I'm just giving an example of the steps that might be involved. And let's say that you got a patent on it, and you found some other doctor was doing these exact same steps. Is that other doctor infringing your patent? Well, it sure sounds like it, right? But will you be able to sue for any damages against that doctor? No, you won't. And this is because of a special statute that was enacted to protect doctors from being sued for performing patented medical procedures. There are very few exceptions to patent infringement, so how did this come about? The history of this exemption began in 1993. There was an ophthalmologist named Dr. Samuel Palin. He had a patent on cataract surgery procedure, and he sued Dr. Jack Singer. Now, Dr. Palin, he was the one who had the patent. He lost the case because the court found there was no infringement, but it got some doctors scared that they could be sued for doing medical procedures. So with some pressure from medical groups, Congress passed a special exemption statute. The statute is 35 U.S.C. 287, and I'm going to paraphrase it a little bit. It says, with respect to a medical practitioner's performance of a medical activity that constitutes infringement, it shall not apply against a medical practitioner or against a related healthcare entity with respect to such medical activity. So we have a few terms here. Medical activity is the performance of a medical or surgical procedure on a body, and a medical practitioner is anyone licensed by a state to do that procedure. So this would include doctors, nurses, probably other people like dentists and optometrists or chiropractors. I don't know how much of this has been tested in the courts on who counts and who doesn't count. Then there's a term against a related healthcare entity. This means that you can't sue the hospital or medical group, nursing home, medical clinic, or HMO, or things like that. What about veterinarians? It actually doesn't seem like they count because it says that a body shall mean a human body, organ, or cadaver, or a non-human animal used in medical research or instruction directly relating to the treatment of humans. So maybe in some animal research situations, it would count and vets would be protected with this exemption, but not if they're probably just doing vet care for the sake of animal care. So what's the point of getting a patent on a medical procedure then? In some situations, there may be no point, especially if the procedure uses non-patented devices, like a basic suture that already exists. But the exemption doesn't apply to actual devices. So if there's a medical procedure, and in order to do that procedure, you have to use that device that you patented, then the doctor isn't protected from patent infringement for using the device. The other reason why it may be useful is that the exemption doesn't cover everyone. It covers medical practitioners and related healthcare entities. If there's a biotech company and that biotech company is telling doctors how to perform a surgery, then the biotech company isn't covered in the healthcare because it's not a healthcare entity. They also can't sell software describing the procedure. So in theory, you could sue them for indirect infringement because the company is telling doctors to infringe a patent. One interesting thing is that if a tool is needed to perform this procedure, the tool doesn't need to be patented itself in order for there to be infringement. Let's say that someone has a patent on a medical procedure. A company designs a tool, and really the only reason that tool exists is that someone could do this procedure. Even if the tool isn't patented, the patent holder can sue the company that makes it. Now, why is that? It's because if there's no other substantial, non-infringing use of the tool, then basically the company is telling doctors to infringe the method patent. The doctor can't be sued, but the company that makes the tool to allow infringement can be sued. So if you're an inventor and you have a patent on a medical procedure, you might want to enter into a licensing agreement with a tool company so they can make the tool used to perform your procedure, even if that tool can't be patented. It's important to remember that the exemption doesn't apply to medical devices, drugs, the use of a drug or device, or a biotechnology process invention. The exemption really is just about pure procedure patents. So if you're a physician, this is good news for you, but if you're an inventor and wanted to patent something and came up with a new surgical procedure, it's not so good for you. It really just depends which side of the aisle you're on, whether you like this exemption or not. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamentpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamentpatentlaw.com or call me at 424-281-0162. I'm Adam Diament, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. For more information and help with your own intellectual property needs, contact Adam Diament directly by going to diamentpatentlaw.com. That's DIAMENT patentlaw.com. Or click the show links to connect by phone, text, or social media. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.